Okay, in compliance with the Open Public Meetings Act, adequate notice of this meeting was provided by posting on the City Hall bulletin board and by notification to our newspapers of record. And I asked the secretary to please make this announcement part of the public record. And Donna, could you give us a roll call, please?
Yes. Mayor Petty, Mr. Timbers,
I'm here.
Mr. Peterson,
Here.
Mr. Walker,
Here.
Mrs. Johns,
Here.
Mr. Garth,
Here.
Dennis McKenna, Michael McKenna,
Here.
Mr. Molyneux,
Here.
Mrs. Torres, Mr. Dixon,
Here.
Mr. Hare,
Here.
Mr. Manos,
Here.
Mr. McGowan,
Here.
and Secretary here.
Okay, thank you, Donna.
You're welcome.
Minutes, February 16 meeting. Is there a motion to approve or any comments?
I have a correction.
Go ahead.
On the roll call, I am absent. I was written down as absent. I was there.
Thank you. I'll correct that.
Okay, thank you, Todd. And any other discussion? Is there a motion to approve minutes? How about a second?
Second.
All in favor, please say aye.
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 Anyone opposed? Minutes are approved. Thank you. No resolutions. We'll go right into new business. Ryan has circulated a formal or so document of the findings of this discussions or whatever, and we're here to buff it up a little bit, I guess. And Ryan, go ahead. I'll let you.
Sure, I'll walk everybody through it. Hopefully you had time to read it. We issued a memorandum today for a review and recommendation for cooperative sober living facility land use regulations. I'll sort of just go through paragraph by paragraph. The city has had a whole bunch of recent interest from facility operators looking to locate facilities in the city. And while there are not many in the city yet, it's always best to regulate land use before the development occurs. Once the development establishes itself, there's really nothing you can do. So before negative patterns emerge, you want to regulate land use before any kind of development occurs. Excuse me. So again, we noticed that we have a growing need, and we have no mechanism to regulate development patterns at the moment. So we wanted to look and see what does effective regulation look like, and would it be appropriate in Egg Harbor City, and if so, in what form? So one of the first steps we did was reach out to DCA for guidance. They directed us to a report that was prepared for the city of Woodbury. That report was a thorough literature review. They list like 50 plus sources. So it's very well documented study. So we relied on the findings of that report for much of the basis of this report without reiterating that literature review. Figure if DCA has reviewed and approved it and recommended that, then that's a pretty good basis for leaning on that report and its findings. The city of Egg Harbor, coincidentally, has a lot of similarities with the city of Woodbury. It's sort of an older city. There's a large dated housing stock. There's a lot of homes that are a larger number of bedrooms than is common today. It's from an era when their family sizes were much larger and houses were therefore much larger. The city also has a rail station, bus, and a walkable downtown. All of these are valuable assets when someone's looking at locating a rehabilitation type facility. Maybe not all residents have access to vehicles, so public transportation is a useful feature and an attractive option for operators and obviously the residents. So we looked into what can the city look at and regulate, and what is outside of the city's purview. And I believe we visited this before. We discussed that Oxford homes are not subject to regulation. They classify as a single family use. They're allowed to exist in any single family. They operate as a family unit. They're run by the individuals that live in them. The city can, however, regulate what are called Class F facilities, which are licensed by the state. Again, that cooperative sober living facility title is usually what's associated with them. And generally speaking, they must be permitted in all single family zones, but you can make them a conditional use in single family zones. And then you can set the conditions, reasonable conditions, which we'll get into. So one of the critical aspects of a successful rehabilitation facility, Class F facility, and other types, is that you're seeking normalization for the residents, and it's sort of an immersion into an established neighborhood. That them becoming part of the neighborhood and being integrated into a neighborhood is really what makes it effective. This is not an inpatient treatment option. It's supposed to be a facility, in a neighborhood that otherwise is, it's not an institutional use. It's just in town. With that, concentrating these facilities and creating sort of a de facto institutional zone is detrimental to the facilities themselves and their residents. So, if one moves into the street and then another one moves next door, and another one moves next door to that, now you're not in an established neighborhood anymore. You're sort of institutionalizing it, which is not ideal, again, for the residents. So what is a sort of recommended practice is separation between units as the conditional use. The condition would be that you're, X distance away from other units. Studies sort of vary all over the place across the country. It varies anywhere from a quarter of a mile down to a couple 100 feet. But it seems like a lot of studies sort of land at approximately a city block length, which in the United States, a standard city block is 660 feet. In Culver City, it happens to be 600 feet. So what we looked at as being appropriate separation between facilities was on the block face. So if a facility faced an avenue or terrace, or I'm sorry, the face with whatever frontage they have. So if there is, a facility that faces an avenue, it has frontage on the avenue and the terrace, a 600-foot separation along that block face, both the avenue and the terrace, would be appropriate there. If a facility is on a street in the city, which are all the ones that, are the short blocks, the 150 feet, 300-foot separation along the street face should be sufficient. 300 feet, there'll be two intersections between each facility. So while it's closer physical distance, your opportunities for your paths to diverge are more, and the actual separation from a mingling and habitation perspective is much more because of those intersections breaking up the distance. And then the third way that we looked at was any facility that was within 300 feet of an intersection, you would have another 300 feet along the intersecting street. So if you had one lot in off the corner, and then you had one facing the street that did not have any frontage on the terrace or on the avenue, the first two, that would sort of be a little loophole there. So that approach sort of allowed it to effectuate that street requirement of a 300-foot separation, where the other two don't necessarily intersect. So again, a 300-foot separation from an intersection that has another facility within 300 feet of it. The next aspect we looked at was the possibility for separation from community facilities. The first thing that came up with areas that require special protections is the drug-free school zone map. Those areas are already acknowledged and designated as requiring special protections, so we felt that was a good place to look. We then looked to see, what was sort of the interaction between these two, and a bunch of studies have pointed to a relapse being more likely within the first year of rehabilitation after inpatient treatment. They'd be far more likely than just use by the general population, whether it be drug or alcohol use. So that raises some concerns about locating them inside the drug-free school zone. And again, the drug-free school zone, while that map is called that, it lists 3 different types of facilities. I'll get into that in a second. So in that drug-free school zone, there are very harsh penalties for being arrested for illicit substances, particularly with intent to distribute or distributing. They have a minimum 3-year prison term. And for anyone who's sort of on the path to recovery, that is a very quick way to derail your recovery. there's a lot of talk of drug reform and prison reform and marijuana legalization, and recognition of addiction as a disease, and going to prison for 3 years is not, the best rehabilitation method. Let's put it that way. It's not helping the individual to get better.
It'll damn sure cure the disease.
I mean, at least for some short period of time, sure. The reintegration portion at the end, that could be a little more difficult, but story for another day. Anyway, so we reviewed each type of facility that is associated with the drug-free school zone map and identified for special protections. We looked at parks and playgrounds, and then public buildings and their relevance to these types of facilities. And those types of facilities, parks, public buildings, offer recreational opportunities and services potentially to CSLR residents. So while we believe special protections are warranted from these types of facilities, there's a potential detriment to the residents to limit them from being close to these facilities. To say that you couldn't locate near Lincoln Park or near City Hall, facilities which again potentially offer resources to these individuals, could be detrimental to the residents. So we did not recommend enforcing separation from those types of facilities. When we reviewed the third category, which is schools, we noted that schools are sort of uniquely focused on children and providing services to children. There are no services offered at a school that would be relevant to CSLR resident. It's again, schools are just, their unique mission is to provide a safe place for children and to educate children. And we believe that is identified in the drug-free school zone law and map itself. The schools are afforded a 1,000-foot separation, whereas the other facilities are only afforded a 500-foot separation. So we think that sort of inherently recognizes the importance of schools and the importance of keeping illicit substances away from schools and school areas. So our recommendation was to enforce the 1,000-foot, or to adopt an ordinance which would require 1,000-foot separation from schools as part of the conditional use. So in summary, the recommended ordinance to City Council, and obviously we work with the city solicitor as needed, would be to list CSLR facilities with up to 10 residents as conditional uses in all residential zones, to require minimum separation distance from any other proposed CSLR or existing or proposed CSLR facility in accordance with the following: 600 feet along the frontage of any street, or I'm sorry, with the frontage of any avenue or terrace, and 300 feet along the frontage of any street, and then 300 feet from any intersection which is within 300 feet of another facility. And then the last restriction would be requiring the minimum 1,000-foot separation from any school in accordance with the most recent drug-free school zone map. So that is our recommendation to the board. Again, this is sort of in advance of the rest of the re-examination, given the strong interest that has been brought to the city's attention recently. Again, the time to look into something like this and adopt applicable regulations is before it occurs. So we sort of advanced this portion. The memo will appear most likely in the master plan re-examination report when that's issued as a section in that report. Normally it would have just been conducted under there with the normal course of business, but again, timing sort of advanced this effort a bit. So that's really it, unless somebody has any specific questions or wants to go through any parts of the memo or
Yeah,
thoughts.
thank you, Ryan. Leo, you have any comments before I open it up for the board?
No, I don't. I think Ryan did a good job summarizing it. It looks like you obviously put a lot of thought into how to separate these facilities, and it all sounds good to me.
Yeah, I read hundreds of pages of studies and other reports and other ordinances, and there's a lot out there, and it's some contradictory, and sort of trying to weed through and find out what's appropriate was a challenge, but I think we landed in a good place.
Good job. Any questions, comments from the board?
Yeah, Ryan, I got a quick question.
Sure.
Is there any Is there anything a neighbor can do if you find out that one of these homes is coming next door? Is there any action that you can take that could possibly affect whether it will in fact come next door or not?
Sure. So it's really difficult to force a facility or require a facility to not locate it at a specific site. I mean, that's sort of why we came up with these conditional use standards for separation. Other than that, they're really allowed to exist in neighborhoods, and you can't prevent them from moving into any individual home. You know, I understand residents' concerns sometimes, and we you know, with existing facilities and potentially problematic other uses, we sort of always tell residents you have to just document. There's nothing you can do to prevent you know, from coming necessarily. If we have a conditional use hearing, if we have to come to the board, you know, if someone's seeking a waiver, they can come and you know, speak up against it if that's their prerogative. But if it's something that is, you know, permitted in the ordinance as a conditional use and they meet the conditions, you know, you sort of have to allow it. Federal law dating back to the 70s and then numerous modifications through state and federal courts sort of require that you allow these facilities to exist and come into your city and require them to be permitted in all residential zones. Frankly, you can't just say like, oh, you're only allowed in this zone. You know, you sort of have to let them exist and establish themselves. So,
Anyone else from the board?
Thank you, Ron.
of course.
I have a question.
Go ahead, Marie.
I noticed 2 new houses on Baltimore Avenue, in the 5 and 600 block.
Mhm.
And the neighbors told me that they're going to be group homes. Is that true?
So one of the builders of one of those houses, at least that I'm aware of, is an owner of another facility, another similar facility nearby. That same builder has built, I don't know, 5 or 10 homes over the last 10 years in the city, and none of them are facilities. So,
But it's not approved, right? This
well,
is
it would be approved as a single family home, and then they have to seek, depending on the type of facility, they may have to seek a license from the state. There is no approval process on the city side to license a Class F or other facility. So again, but what we have to do is say, okay, you can have these, but it is a conditional use. So in order to be allowed in the zone, you have to meet these conditions. And that's what's at the tail end of the memo, is what's recommended as the conditions that a facility would have to meet. It effectively requires separation from other facilities.
So that doesn't mean anything, this meeting? I mean,
So-
they already built the house.
Marie, we can work within the guidelines that we can legally defend. We're trying to make it so that they're not going to put 3 of these facilities right next door to one another.
Right.
So the purpose of this recommendation and to add to the master plan and to present to council is that, you know, we recognize that we're going to have to allow these, but we don't want them next to one another or so close to one another that it starts to change the neighborhood, which is the reason that they want to integrate into the neighborhood. So that they can't come in and put 10 of them on a street together. They haven't accomplished anything.
Yeah,
Well,
most of
these
the
homes
research,
aren't
was gonna say,
that
most of-
far apart.
most of the research for these types of facilities comes out of Florida, because there was there's been a problem over the last 10 or 15 years with facilities down there. And what happened was they sort of clustered. You know, a facility owner, it was easy for them to buy the house next door or the house down the street. They were already familiar with the real estate market. They already knew the house, you know, because there was subdivisions where it was just sort of copy and paste. So what would happen was 1 or 2 facility owners would own, you know, 10 or 15 of them in a 10 block radius. And it really changes the character of the neighborhood. You know, what makes these facilities successful is when you're integrated with an established neighborhood. Like it says, it's normalization. They just want to, you know, what makes them successful is just being your neighbors. The problem is if there's other facilities next to them, again, I mentioned this in the report, the rate of relapse for that population is higher than the rate of use for a formerly addicted population, non-patient population. So when you have the risk of having many of them together is some of these people will relapse. That's just statistically, accurate. And when you have more of them together, they will relapse and drag others down with them. So the idea is you have a limited number of people living sort of as a family group in an established neighborhood. People are going to sort of falter along their path. But the idea is to try to, have a support system around them and have them not institutionalized and surrounded by other people with the same struggles. So that's the impetus for this.
I know that doesn't make you feel any better, Marie, but that's
No,
that's where we're at.
Again, state and federal law really controls what you're allowed to do. You can't.
yeah, well, Abe Carver, was, starving for new people to move in. And, this guy's making money to, I don't get it. I just don't get it.
So Ryan, are these facilities taxable like all other property?
It's a single family home for all intents and purposes. Yeah,
Even the state run facilities?
I believe so. Yeah.
Okay, hello, Ms. Mayor.
Hey, I'm glad I could make it.
Okay, and anyone else from the board have any questions or comments on our discussion? Okay.
Wait,
So,
I do want to say something. I don't know if Donna had informed you about this, and I don't even know what you were talking about. I'm guessing it was Ryan's attachment that he sent out. But, I did call the state and I talked to Mr. Rayburn, I believe his last name is. His name's Jay. And he did say that as of last week, there were no new applications for any, what do they call them, Ryan? Co-op?
The class
Cooperative
F
sober living
license.
residences, CSLR facilities.
There was a rumor, I guess, a couple weeks ago about one on Liverpool or London Avenue. London. That is not true. They have not received anything. Now, it doesn't mean that it might not be Oxford House, because you don't need state approvals, obviously, for that. You can put that in wherever. So they haven't had that, and they haven't had anything for 701 Baltimore, which was a real concern because that one is also right behind the school. So,
Yeah.
so that's a good part of it.
So Ryan, that brings up a question for me. If you have an Oxford home and one of the, Class F homes, do you have to count them separately, or does one block out the other?
So an Oxford home is classified the same as your house. It's just a family living in a house.
So you could have this Oxford model and you could have the other model all in the same
You
neighborhood.
could have a whole block of Oxford homes. Yep. There's nothing you can do
Do
about
they
that.
pay taxes too?
Yeah, it's still a privately owned home, but the people living there are living as a family unit, and it's sort of self-regulated within the home itself.
I'm sorry, Lisa, I just didn't want to lose that thought. Did you have something else?
No, that's all. I just want to let you guys know that, we're good so far and haven't heard anything. I did ask that they notify Steve, our zoning official, if there is anything coming their way as to these homes. So he said he would do it, because the last one slipped through, which Donna recalls very well. We didn't know about that until the CO inspection. So
Yeah,
hopefully with the checks and balances, we'll be able to manage this situation.
Well, and if the city were to adopt an ordinance to make it a conditional use, they would have to bring it with their intent to Donna, to that office prior to establishing.
So Ryan, just to be clear on the separations and what if you had a house on Chicago Avenue and then one on Buffalo Avenue, and they were neighbors across the alley?
So that would be covered by this. It's 600 feet along any frontage of any avenue or terrace.
Okay.
So it's a standard home in Egg Harbor City faces the street and the terrace. So you'd have 600 feet along the block face, so directly along, straight along the street and the terrace in both directions, 600 feet.
So the most that we could have then would be one per block.
That's the intent, yeah. In fact, we had written it up as one per block, but the scenario of them being sort of, catty corner on different blocks came up. So the solution at the bottom, the 300 feet from any intersection, which is 300 feet from another facility, that really covers it. If you're within 300 feet of intersection, 300 feet from every direction from that intersection, would be blocked off by the ordinance. Because like I said, otherwise you could have ones that are technically not on the same block, technically not on the same street or avenue. If you had one facing the street, one having facing the avenue, catty corner on different blocks.
Mhm.
It's sort of a, unique scenario, but it could occur. So
There's no state or federal laws that have defined these distances or anything. It's up to us to come up with something that we think we can live with.
yeah, there's numerous other examples. Like I said, they range all the way from about a quarter of a mile to a couple hundred feet. The city of Woodbury settled on 528 feet, which they don't have a nice even block pattern. So that number worked out as a formula of being like a 0.01% chance of interaction between neighbors. It's kind of obscure, but that's where they landed because they didn't have any fixed marker. Again, the general recommendation is a block. We have fixed block lengths. They're 600 feet. They're less than a standard city block. So we felt that that was an appropriate number.
Well, not to throw a monkey wrench in the works at the last minute here, but I don't think that's tight enough restrictions. And this is just my opinion. I say you stand in the intersection and you draw a 600-foot radius and you have one of these facilities in 4 blocks.
So we looked at the radial approach. The problem is that the way that this spacing works in Egg Harbor, you're always going to catch part of another block that is like 3 streets over. And we felt that was going to be subject to challenge and have difficulty holding up.
Well, and it's just me, but it is my money because I'm paying taxes too. I say, quit getting down on your knees because you're worried that somebody's going to sue you. Let them challenge it. And if we have to give up, we give up. But you can't continue to, stick your head in the sand and hope that it's going to go away. You got to stand up and say, hey, we don't like this. And this is what we would like to have. And if you don't like it, well, then let's go to court, because they don't want to go to court any more than we do.
I'll defer to Leo with that.
Again, that's just my opinion.
It's a risk.
I there's always a risk, and unfortunately, these federal laws have what's called fee shifting. So if you lose, you might have to pay their attorney's fees. So they have some leverage. They have some leverage there. And it's the city that gets sued, not the planning board. Well, if we we would get sued if we had an application and someone wanted to challenge our decision on that. But
yeah, but it's really all of us, Leo, because we pay the taxes.
Yeah.
I mean, we're paying for the legal defense, but sometimes you have to defend yourself, and it might cost you money. But we're getting pushed around, and not just by the real estate people that want to do these, but by the state.
no, I understand, and it's a balancing effort that that's why Ryan's reading all this stuff to try and come up with what he thinks puts us in the best position possible. But I understand your point.
Yeah, striking that balance is very difficult, and there is no right answer. I can't tell you if you double the length that I recommended that you'll get sued. I can't tell you that you won't get sued with the length that I recommended, to be honest with you. There's no promises. All you can do is look at all of the available guidance, and my job is to give you the best guidance that I feel that I can. We spent a lot of time trying to pin down what we thought was going to be practical, effective, and defendable. And this
and that's as it should be, Ryan, and you did a good job. But as the board, we can comment or
you
ask
can
or recommend anything that we want. And this is just
Absolutely.
my opinion, and I feel strongly about it. Not so much about the particular issue, but to continually spend all this effort to defend yourself from something that hasn't even happened yet. They're going to drag you into court no matter what. I just say, you come out showing your teeth a little bit. You can always smile later, but it's too late when they're in your backyard. You're not going to get rid of them. And not that we should get rid of them. Don't get me wrong. I think that these facilities can enrich neighborhoods and towns if they behave themselves and they
Mhm.
don't park cars all over the lawn and they keep their properties nice and they do everything that everybody else does. I welcome them to the neighborhood.
And they don't expose themselves in front of children and,
Well, these are all things that, again, if you don't defend yourself, if this is happening in a neighborhood, it's up to the neighbors to
Right.
report these kind of things and to document them through code
Yeah.
enforcement and through law enforcement. And if they can't live within the reasonable guidelines that we've loosely established as, just Egg Harbor City, then they shouldn't be there.
Well, that's the laws that exist are there to protect their existence and their establishment. They're not there to protect the residents' erratic behaviors.
Yeah.
They do have a license. They answer to somebody, document, report, and when it comes up for renewal, those things will need to be considered.
well, and
Best
not
I
for
can tell you
nothing,
in
but
existence, so.
if people would get more involved in the Coalition for a Safe Community and, learn what they can do to make themselves safer, we can get more enthusiasm among the people to call code enforcement, to call the police department. We have the nuisance order in place where 10 nuisance calls, the landlord gets like $1,000 fine or something, and it keeps going up. But people just, they don't want to be the troublemaker in the community. I just a couple weeks ago, I handed out letters explaining the situation, an update on the situation, and I gave them these little coalition magnets for their refrigerator. And, if we can just get the word out with educating the community without being prejudiced, because we don't want to do that, but just educating the community on what their rights are. I mean, we do have rights, and I have assurance by the state that if these things are occurring and there's code enforcement violations, that they will take care of them. You just have to let them know. So when I went out to the public, I gave them code enforcement's number. I gave them the landlord's number. I gave them the property manager's number on a business card. So they have the information they need. We have to get information to the people that have to live in these areas so that they have a resource to go to when these types of things happen. So it's really our responsibility to do that. And one way to do it is the coalition. There's many other ways you can do it, but one of them is the coalition.
And any other comments from the board?
Jack, what's the difference between the two different types of homes?
Go ahead,
Legally.
Ryan, please.
So an Oxford home is a home that is managed completely by the residents that live in it. They operate as a family unit. They share cooking, cleaning, expenses, etc. So the state and federal government have determined that just because they're not blood related doesn't mean they're not existing as a family within the home. So that meets the definition of a family and can exist the same that your family or Jack's family or my family can in a single family home without any additional regulation. The CSLR, Cooperative Sober Living Residence, is a managed facility. It's owned by a company or an individual. It has a manager. People pay to be there, and they don't necessarily have to cook or clean or do any of those things. Activities are provided, services are provided to them. It's more, it's sort of all of these are transitional housing, but again, it's a managed development or managed facility rather than a self-managed facility.
So the Oxford is state-owned?
The
No.
Oxford home could be owned by anyone, an individual, a company,
Okay,
but essentially each resident that's living there is paying rent and living together as a family.
okay.
And, a recourse for that is in code enforcement also. Like, you have to have enough space. Code enforcement goes in and measures those spaces. If they have 11 residents, like they propose to have on 658 San Fran, the code enforcement goes in and measures the square footage and makes sure that there's enough space for people to live in there. So you have a little bit of a recourse there as to how many people live in the house.
Yeah, you're limited to the number of bedrooms and the square footage of the bedrooms. There are international building codes that the city has adopted and follows that govern those things. So yeah, you can't.
No different than any house.
It applies to my house and your house the same way it does that one.
And rental units, you know, how many times have I called Don and said, look, there's a lot of people living in that house right down on my street. Could you go? They go,
Right.
they measure, everything's good. So there are things we can do, but we just have to be vigilant in identifying and looking around at what's going on in our neighborhood.
Yeah, I mean,
So-
any of these types of facilities have the same rights that you do. They do not have supplemental rights. They don't get to, break other ordinances. They have to follow the same rules as everybody else. So if they're not, sort of cooperating and fitting in with what's required, then, you have to, again, as you said, just be diligent and continue to report and document. The same way you would if your neighbor had 10 people living in his house and was charging him rent and, was parking on his front lawn. And, it doesn't matter if it's this type of facility or it's just a belligerent neighbor, treat them the same way and the problem should be rectified.
Did that answer your question, Keith?
Yes, thank you.
And thank you, Ryan.
Of course.
Any other further comments from the board? So then what is our next step? What action do we need to take then, Ryan or Leo, if any?
I mean, if you'd like to, you can accept the findings of the memorandum and make a recommendation to City Council to develop an ordinance that adopts or at least, considers the recommendations at the end of it. I'm happy to work with the city solicitor. If you want to recommend that we also investigate, increasing limits, you don't feel that separation is sufficient, you could make that as an additional or supplemental recommendation to the board or to city council rather.
So what's the feeling of the board? You know how I feel. If everybody else is in agreement with Ryan, then we'll entertain a motion to make the recommendations to the next level. Is there any more discussion?
Ryan, is there going to be a master plan reexamination report?
Yeah, so ultimately this will be incorporated as a section in the master plan reexamination. Again, given the timing, we tried to advance this before the rest of the reexamination, which is already proceeding, but not quite, to a report form quite yet.
Gotcha. I mean,
So-
is the idea that gets done before the ordinance ultimately gets adopted though, or?
Well,
We're
that's
going
why
out.
we issued this as a memorandum. So it's sort of, a standalone document.
Gotcha.
Ultimately, it'll be incorporated in this form. We won't revise it. But, I know city council, if this is recommended, has interest in advancing it, fairly
I think
quickly.
that they should move forward with it post haste.
I agree.
Yeah. So that's hence the form and distributing it separately as a memorandum.
Okay, that makes sense to me then.
Okay, there is a member from the public. Dan, do you have any comments on this? We're not under public comments, but you're listening in on the thing there. Is there anything that you would?
Yes, please.
Like-
I had a question. Is there any kind of public notification when some house like this is coming into your neighborhood, or is there any records at City Hall where somebody could go in and find out where they're located?
I don't believe that City Hall currently keeps record. I had Donna pull records for all facilities that we're aware of in town. The Class F facility is kind of a new classification. So I don't know how the city wants to handle that, but again, if we make it a conditional use, they will have to notify the city. At this point, they don't, they can sort of notify the city after the fact. And that's sort of what happened with previous ones.
But
So-
in the case of the Oxford model, there's no notification. They're coming in like a regular homeowner and buying a house and putting people in it. So
Yeah, I mean, in theory, they have to have a rental registration, but that's really it.
yeah.
And Jack, you were on council when we had that Oxford house come into Buffalo Avenue, I think. They actually did approach council through the redevelopment committee and said what they were going to do. So I guess it depends on who actually is.
And I said, was that the one next to Debbie Garinger?
Yeah, I think so.
And
Well,
she
there are
was okay
certainly-
with the facility at that time. I don't know if things have changed, but they were good neighbors.
Yeah.
There are certainly, upstanding facilities and operators, ones who are diligent and make sure that the facilities are run well and that the, individuals are benefiting from it, and then there are unscrupulous operators who are there to collect the rent.
And that's what you got now because of the housing stock and the way the world is right now.
Yeah, I mean, and again, as with anything, once news comes out that, oh, there's a whole bunch of facilities in Florida and people are making a ton of money and it's a mess, there are two kinds of people. There are kind of people that hear, oh, that's terrible. And there's kind of people here, oh, you can make tons of money doing this. So, you never know which ones are going to show up next time.
And
I
if
have
I
another
could,
question.
oh, go ahead, Nanette, I'm sorry.
We have a lot of homes for the developmentally disabled or mentally disabled. Do they play into this as far as the 600 feet?
They would not. This only applies to Class F facilities, which are limited to cooperative sober living residences.
Okay.
There's numerous, obviously this one's F, so there are 5 or 6 before it, but
And those are non-tax generating properties.
They're
Because of-
nonprofits.
some of them are, yeah.
nonprofits through Cody. And I think that there's some, I don't remember, I know there's a couple in town and I don't remember, there's already something, I don't know if it's in our codes or through the state that regulates something in the kind of way that these other homes, but that's a different situation. Those people by no fault of their own have problems. These facilities are for substance abusers.
Yeah, but the homes are not as well kept as they should be, especially the ones on Atlantic Avenue. And, they don't do enough for the people who live in those homes, I don't think.
If
And
those are Cody
tell you
owned,
the
I would
truth.
reach out to them. They're a pretty responsive organization.
Well, a lot of them are
The ones on Atlantic Avenue are
prosecutors'
Cody.
office.
They're
No,
owned by Cody?
They're not Cody. The ones on Atlantic Avenue are not Cody.
No.
Right.
Cody
Cody
has
has
one
ones
down
on
the block
Chicago.
there behind Kowalski Tire. I don't remember whose house it used to be, but there's one there and there's one on the White Horse Pike across from the park. And I don't think there's been
Yeah.
any issues with any of those properties.
well, the ones with the pedophiles, I think that's a county facility they put there.
That was, yeah. At Atlantic, there's a rooming house on both sides of Liverpool Avenue there.
Yep. We get dumped on in Egg Harbor City and some.
Yeah, well, I can't imagine why somebody who's trying to get their life together and get off of drugs wants to come and live here. It's just, I would want to be in a nicer neighborhood where I know there are drugs are everywhere, but
This is where they
not as
send you. with
readily
your-
accessible as they are here.
The property's cheap, that's why, Nanette.
That's exactly right. And it's just a moneymaker for these operators.
Well, and I highlighted
Yeah, I
you're
agree.
walkable downtown, you have transit options. It provides options for these people who don't necessarily have a vehicle. So that's what makes it attractive for the operators, cheap, large housing stock or oversized housing stock and transportation options.
Well, I know we're beating a dead horse, but aggressive code enforcement is the only way that you're going to control it.
I
I have a
agree.
question for Ryan.
Mhm.
Go ahead, Todd.
Ryan, is there a different type of clientele that would be in an Oxford situation rather than the other housing? In other words, is it a high, I don't know how to say it. Is it a higher tier? Is it people that are almost rehabbed, go into the Oxford situation? And I guess what I want to say are the worst of the worst down in the other type of housing?
I know what you mean. For all intents and purposes, they are the same tier, I'll say. I think that you'll find people who are required to be in them might trend more towards the managed type facility because there's less, in theory, there's less personal responsibility at that type of facility. There's someone there managing the facility, cooking meals, overseeing. So there's more oversight, but there's less individual responsibility. For all intents and purposes, it's the same people, but the potential would be to have people who are required to be there to be at a managed facility, I would assume.
And I would imagine there's an age restriction. I mean, you have to be over 18 to.
Yes, yeah, these are not open to minors. That was really why we focused on the separation from schools. There are no services at a school that would be relevant to an individual living in one of these facilities. The only real possible interaction is the detriment that exists. Again, if they would have a relapse, which statistically is likely for, potentially up to half of the residents.
Thank you.
Okay, so then do we have a motion to submit the recommendations of Ryan's memorandum to city council, or what's the next step to follow in this process?
So you would make the recommendation to city council, and at that point, it would be up to council whether to draft an ordinance and advance that, or whether to, ignore your recommendation. But I think that most likely it would be taken up.
And then the ordinance, once if they go with it and they draft it and they adopt it on first reading, it'll then come to us to review as a planning board in ordinance form.
Right.
Okay, so then, Leo, is this a letter that you would write to submit this to the city council, or is that something you do, Donna?
It doesn't really matter. I mean, I think it's really almost a motion to, to recommend that we're going to adopt Ryan's recommendation, and to me, a simple email to the city clerk, just letting her know, and copying the city solicitor or something like that should do it, which I can
Okay.
certainly do.
Okay, so is there a motion?
Motion.
I'm sorry. This is Sean here. I'm sorry. I've been trying to hop. Hey, just quickly, what happens if this motion isn't passed? That just means basically it doesn't go before city council to consider?
Yeah, so I wrote a memorandum to the board. You can take no action. You could vote to accept the findings of the report or of the memorandum and make a recommendation to city council to, consider the recommendations made in it. Or, you could do nothing. That's completely up to you guys.
And if we do nothing, city council can still act. They can still adopt an ordinance.
This is just
It'd be harder to defend later.
Did that answer your question, Sean?
Yes, completely. Thank you.
Okay, so there was a motion. Is there a second?
Second.
All in favor, please say aye.
Aye.
Anyone opposed? Okay, the motion is carried. Thank you, ladies and gentlemen. Okay. Somebody, old business. Bear with me here a minute, folks. I want to share something with you if I can figure out how to do it. Okay.
Oh, yeah.
Can you see that?
Yeah, the
Okay, let's
homeowner-
save that one for last. Okay, this is a stone in my shoe, only because we were involved in the development of this property and the approval, and this is the Dollar General, okay? This is their business model, where they roll all their cardboard and all their trash and everything that's generated in this building. And the truck that comes in to deliver their inventory takes these carts back loaded with trash. And in the meantime, this is what happens. And we get windstorms. This junk from their property is blowing down the White Horse Pike. It's all over Antwerp Avenue, in the woods. They have a facility here to keep that stuff in, but they're not using it. They got the doors open. They've increased the size of it by 20 feet. And there's so much junk in there that they can't do it. But this stuff is left out regularly, routinely. And I know I've talked to Donna, and Steve's been over there to talk to them about it, but they refuse to comply properly, okay? This is what it's supposed to look like. I don't care what it looks like behind the gates there, but that's where the trash is. This is Hamilton Township. This is the Dunkin' Donuts in Hamilton Township. So when you open them doors, it's a typical dumpster, but when the doors are closed, it looks the way that I would like that facility to look. So they're not following the site plan the way that they agreed to, because they signed that they were going to take care of this and that no trash was going to be stored outside. So this stuff that's laying along the thing here, that's stuff that has blown out over the last couple of weeks. Nobody's picked it up. They won't have to. The next windstorm, it'll blow onto somebody else's property. So Donna, you know that we have spoken about this numerous times. I'm recommending that the board send them a letter and say that they must come back before the planning board, and they're going to have to either increase the size of their facility or you're going to have to take it to the next level, because you've already been there and cited them for it a couple of times, if I'm not mistaken.
Yeah, I can send the guys over tomorrow to address it again in the meantime.
Well, I would like to comment on that. Donna, we had a terrible problem with them on the trash situation. I think everybody remembers that. I did reach out to the manager or whatever they're called in that capacity, and I was able to get through to him on the severity of what we're going to do. And if you do have the manager or the regional, whatever, whoever runs these stores in our area, I would be willing to call him and have another conversation with him, because I can't recall his name, to be honest with you. If you could send me the contact.
Okay.
Reach out to them. And the other problem is, Jack, and I don't know if you're aware of this, but since the courts have closed and we've gone virtual with just about everything now, the code enforcement issues from the communities have been pushed to the back burner. So even if you write them a summons or fines or whatever, they're not getting in the court systems now. They're taking all the other cases first, and code enforcement is in the back of the line. So
I get it, Lisa, but at least it's documented and it's on the record. And at some point, when they catch up with it, you're already in the system.
Right, and I agree with you on that. However, you know, when I spoke to the gentleman before, I told him that basically we can fine them $1,000 a day if they don't comply. We can levy a fine on them every single day that they're not in compliance. And that really hit home with them. So I'm guessing that this would be another situation besides the trash littering their property in the front, that and their I think it was the grass that we got them for the last time. They were horrible with the grass. The fine that can be levied on them every single day is really what hit home with them, but they may not know that. So I mean, like I said, I'd be, as long as we can actually fine them every day, I can relay that information to whoever's in charge over there and maybe get some results, because I did get results the last time. I mean, you have seen that the grass has been cut, right?
Yes.
I haven't seen too much trash out front lately, so.
Well, these stores are all over Atlantic County, New Jersey, all over everywhere. And you go to every one of them, except the new one that you just put in Mullica Township, and they all follow the same pattern. They've got their racks out there with the trash on them. The trash is blowing all over the neighborhood.
Yep.
And I understand that, you know, that's convenient and economical for them, but they're destroying the neighborhood.
I'll pose a question to Leo. Could you cite them for littering?
Yeah, I don't see why not. I mean, there's probably a whole sorts of things in our ordinance that you can cite them for. And to the mayor's point, and I don't have our property code in front of me, but the daily fines up to $1,000, a continuing violation for every day, that they're in violation. Littering, property maintenance, failure to comply with their approved site plan, or conditions of approval, failure to comply with those. I don't have the decision and resolution in front of me, but all those things are potential.
Yeah, well, this is not a new problem. This has been going on for a couple of years, and they straighten up for a little while, but this just degrades. And I know, look, I see what's going on with the White Horse Pike, so everything's a mess anyhow, but nonetheless, they have to do what's right. And it's not right. When your stuff is blowing on everybody else's property, that's not right. You just shouldn't do that. And we shouldn't have to fine you to do that. Somebody in management should be taking a responsibility to come there and tell them to clean up the store. And listen, I don't want to, beat this thing to death, but you have the same problem at Walgreens. You have the same problem at Incolingos.
Yep.
And if we don't say something about it, it just continues and this grows. It's like bunny rabbits. When you see one piece of trash, there's 10 there. And
Well,
while I'm on a rant,
Yeah.
okay, as far as complying with site plans, the new liquor store across from Wawa agreed as part of their resolution that all trash was to be stored inside.
Mhm.
There's 2 dumpsters there with no enclosure.
Donna, I did bring that to your attention. I sent you pictures of that too, and that still hasn't been rectified.
All right.
That they don't know that because maybe they bought the property, but part of the resolution says that if they're going to keep all trash inside, and if they wanted to do it outside, that they would have to construct an enclosure like everybody else does of the proper materials, similar to the ones that we just looked at. So let this be a teachable moment here when we get these site plans before us and they insist that they want to put the trash inside. I'm saying absolutely not. Because here you go, something changes hands and there's no provisions in place to take care of the trash, and they're going to do it anyhow. So I understand that it's all money, but that's not, that I can't worry about that. We have to worry about the neighborhood and what it does to the neighborhood when they don't maintain their facilities properly. And if we don't force them to put the things in place that make them able to maintain their facilities, then shame on us. The problem is we have to enforce it. And I know that there's a lot to do for the staff that you have, but nonetheless, if we don't let somebody know that it's going on, nothing will get done. So apparently both of those are already being addressed, Donna. Or at
Yeah,
least-
I wrote everything down. I'll go over everything tomorrow with the guys.
And Jack, I did also address Walgreens. I went in and talked to the manager, and I basically told her that we want to be good partners with them, but they really have to clean up the trash by the bus station, if that's what you're talking about. I offered to put 2 trash receptacles, 1 recycle and 1 trash, by the bus station, which I did. I had Public Works do that. I haven't noticed a problem since then. It looks pretty clean to me. And I did
It's the alley where their trash storage is, Lisa. It's all down 7th Terrace there. Is that 8th Terrace?
Is that
The whole block from Atlantic back behind there, the trash is all blowed up against both sides of the terrace. Their enclosures around the side of the building, they don't break the cardboard down. They just throw in the boxes and expect that, somebody else is going to do it. And the next thing you know, the cardboard boxes are blown down the street the first time you have a windstorm. So they have covers on these things, but they're not using them. And, it's difficult to go in there and always be on somebody's case all the time, but you have to do it because I don't think any of us would do that with our properties.
Right.
So I'm done. Thank you for letting me blow off steam. Any other old business?
Well, the one other picture that you had was their basin.
The basin, yeah.
Yes, I saw that.
So,
And their trees. Do you
Well,
see
the-
that? Dead
Brian,
trees.
they have gone in there several times and maintained that basin. I mean, it's not performing, but nonetheless, they've been in there and cut all the trees or the weeds and everything out of it. But that was after a particularly rainy period. I don't know if it's still standing or not.
the neighbor reached out to me because they are still having problems with what I believe to be groundwater breakout onto their property.
Really?
His backyard is sopping wet. It's a mess. His trailer is like flooding his yard. So he provided me with a whole bunch of pictures. There's water all over in different spots in the yard. The basin was full for at least 6 days. So at this point, their basin, I'm looking for the dates just to confirm, but at this point, I believe that their basin, from March 3rd to March 9th, he sent 2 pictures and the water level went down maybe 6-9 inches. So at this point, their basin is in a failed condition. If it doesn't drain within 72 hours, it's failed. So we're working on putting together a letter to them to say, you got to get back out there and do it again. We told you when you came to the board, you should do more than the minimum soil replacement underneath. You refused, you did the minimum. So get back out there and fix it again.
Okay, great. Thank you.
Mhm.
Okay. Any other business? Any other comments from the board?
One thing I do want to add, that the trees that they agreed to plant too, Ryan, are also dead, and they never did replant them. That's
Yeah,
the location.
we, they were telling us they were on the cusp of doing them and then they burnt down. So,
Right.
you
So,
know,
whatever.
but
And
yeah, we got to pursue that again.
I guess, thinking ahead to the rest of the master plan, maybe some things we could think about that are almost similar to the issues we're having with the Oxford House and the halfway houses and the cooperative living, or whatever you want to call them.
Mhm.
Airbnbs and also frat houses. I know that there's been many things struck down legally to preventing these things from coming into the neighborhoods, but not the Airbnbs. I did present the Airbnb issue to the council during COVID because we found that there were a lot of people coming into Egg Harbor City from New York that were either camping on city property or maybe renting places to get out of New York City. And it wasn't received well by council, apparently, because maybe there's some connections with real estate on council. However, I think it's important that council does consider it, because if you do read the literature on Airbnbs, I don't believe it's something that we really want in Egg Harbor City. But, and then the frat houses, I have one right down the street from my house, which is nothing but a nuisance when school is in session and kids go to school. But, you know, just something to think about. I don't know what we can do about it, but it should be, you know, should be something that's considered.
Thank
Yeah,
you.
we can definitely look at that.
Okay. If there's no other business, we'll entertain a motion to adjourn. Thank you, ladies and gentlemen. Is there a motion?
Make a motion.
Second.
Second.
All in favor, please say aye.
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 All right.
Anyone opposed? We are adjourned. Thank you, folks.
Thank you, guys.
Thank you.
Good night, everyone.
Good night,
Good night.
everybody.
Good
Thank you.
night.
All right.